and that's the extent of their power. But it's a power that cannot be questioned under our system, and that is absolute. Two reasons for that. A not guilty verdict cannot be appealed, and jurors cannot be punished for their verdict, even if it goes against the letter of the law. And the oath that they're asked to take is actually a false oath because it's not really enforceable.
It's often said, Don, that there are 4 boxes to defend freedom. Would you like to elaborate on those?
Sure, probably in order of which one you go to first. There's the soapbox, which is the First Amendment, the right to freedom of speech, and there is the ballot box, which, if we're not talking about electronic voting and vote scam and things like that, that's the ability to elect representatives in a constitutional republic. Both of those are under attack these days, as we know. The third box is the jury box, and the fourth box, of course, is the cartridge box. Now, the cartridge box is the last resort, and we all hope that it never comes to that in defense of our freedom. So trial by jury is getting right down there, though. Once you get to trial by jury, you haven't got many options left to preserve our freedom, and that's under attack, too. So trial by jury as an institution is under attack in several different ways. Just recently, we had a juror in Idaho who was actually arrested for voting her conscience in the jury room, and that was they finally had to dismiss that. But I mean, that's what it's come to, and we've got pressure from prosecutors to intimidate people with charge multiplication so that they end up pleading guilty. Even if they're innocent, they sometimes plead guilty. So there's all kinds of ways that trial by jury is under attack, and not least of which is their attempt to intimidate the juror into thinking that they don't have the power of jury nullification. Why
is jury nullification under attack?
Well, because if jury nullification becomes really widespread, it would be hard to sustain the current load of bad law that we're saddled with.
When our country was founded, Aaron, all of the citizens understood that they had the right to nullify bad laws and to refuse to enforce bad laws when they served on a jury. And because a jury is an exquisitely constituted body of 12 disinterested citizens, it doesn't mean that we had scofflaws running around. It meant that when 12 people sat down and deliberated together, they could determine as members of their community whether or not they wanted to enforce those laws. But what has happened over time is that there have been some decisions which first said the judges no longer had to inform juries that they had this authority, and that because everybody knew it, it was assumed that everyone already knew that they had the authority to nullify. And then that was taken and eventually was transmuted or warped into saying that even attorneys in court could not tell juries they had the right to nullify. Not that they didn't have to, but that they couldn't. About the only people these days who are able to inform jurors in the courtroom that they have the authority to nullify or to veto bad law are people who represent themselves and have more latitude than do lawyers who, of course, being members of the bar and officers of the court, can be punished by losing their license or forbidden to practice in certain areas if they do something which is not amenable to the judge. So we've lost this authority which we've always had over time, and as the whole system of juries is being attacked, nullification is not only being attacked, but we have seen in writing in jury instructions, one state from the state of Washington, it actually says in their jury instructions that nullification is against the law. It isn't, and so that's why we're here, to help people exercise this authority that they have. When a jury is constituted at a trial, it is the highest authority in the courtroom. It has higher authority than the judge. As Don said, that their verdict cannot be appealed if they find the defendant not guilty. So we're not teaching something new. We are restoring a right as much as when this country was founded, we had the right to keep and bear arms without the government infringing upon that at all. We had, at that time, jurors, private citizens, had the right, when they served on a jury, to nullify or veto or refuse to enforce bad laws or misapplied laws. And so you can see how there is this erosion of the free exercise of our rights that goes fairly well across the board.
Our guests today are Elo Jones and Don Doig of Fully Informed Jury Association. Elo, I have another question for you. It's along the lines of what you were just talking about. If someone is called for jury duty, are there other obstacles that are put in front of them? Are there other things being done to make it more difficult for a juror to be honest and to judge the facts of the case as well as the law?
Yes, Aaron, these days, as a matter of fact, that's an excellent question. And for some of your listeners, if they're called for jury duty, they may face this during voir dire, which is the process of selecting the actual jurors from the jury pool. They may be asked, for instance, if they know about jury nullification. They may be asked if they know about FIJA. They may be asked if they're willing to follow the law as it's given to them by the judge without question. They probably won't add the words without question, but that's what they're implying. If they know about FIJA, if they know about jury nullification, if they say they will follow the law as long as they don't find that it's being misapplied, if they make any conditional responses to that question, the chances are about 99 out of 100 that they will be excused from jury duty. If they, in fact, and we had this happen, if they would, in fact, say during this process of questioning potential jurors, if they would raise their hand and say, I want, as I understand it, I have the right to nullify, Your Honor, I think I have the right to nullify the law if I think it's being misapplied or it's an unfair or unjust or unconstitutional law, and I understand that that's my right as a juror. The judge may dismiss the entire jury pool as being tainted.
Well, that could be good, depending upon the circumstances.
All those people will go home and think, certainly.
Might be a silver lining in that club.
But that is an obstacle that jurors face, trying to get on a jury and be honest by saying that, yes, they understand that they have all this authority. And then if they are on the jury, as we just had with this case in Idaho, which Don mentioned, and during jury deliberations, you might say something such as, well, I don't think this law is really fair, or I answer to a higher power, or I don't know, I think the way the police gathered evidence is a violation of the person's rights, even though the judge said we had to ignore that. There's a good chance that they will be removed from the jury, and we know of instances where jurors have been prosecuted for felony perjury because they have taken the oath and then made statements like that in the sanctity of the jury deliberation room.
That still remains really rare, though.
So far.
Yeah.
So if someone tells the judge that they believe that the Almighty's law is a higher law and more important than the state law, what would the judge's attitude be?